Welcome back, viewers, to another episode of Across the Pond podcast with Martin Cullup and Lindsey Stroud. We're both fellows at the Taxpayers Protection Alliance, and today we've got a really fun guest. It's all TPA in the house. We've got Rosh Marchand. If I'm not pronouncing your last name correctly, you can yell at me on this.
100%. No, that was good.
Okay, perfect. All right. He's a senior. He's also a fellow at the Taxpayers Protection Alliance and kind of our in-house lawyer. He's an alumnus of the Mercatus Center Fellow, MA Fellowship at George Mason University. He's interned at Texas Public Policy Foundation and also at ALEC, American Legislative Exchange Council. And he's done a lot of issues. He's also like our other expert on everything related to the FDA that's non-tobacco. And he's also I don't know if you're a practicing lawyer, but I do know he did just get his JD, but like last year.
Yeah.
So
barred in the District of Columbia.
yes.
Supposed to be barred.
Yes, and he also recently wrote TPA's brief that we submitted to the Supreme Court of the United States of America regarding the wages in White Lion versus the FDA, which is the e-liquid manufacturing firm that sued the FDA over their pre-market tobacco application process. So Ross, thank you for coming on. And if I kind of gave you an introduction, but if you want to talk a little bit more about yourself to your viewers, that'd be great.
Yeah, absolutely. Well, I have been at TPA for, I think, now I cannot do math at all on the fly, but at the very least 7 years. And my role has definitely evolved over time. I used to really just pay attention to policy, but now that I have this fancy JD and I am barred in the District of Columbia, I guess that gives me some legal license to focus on some exciting intersections between law and policy. One through line of my career so far is I've focused a lot on the Food and Drug Administration. FDA law to me is absolutely fascinating. And this brief has been the latest opportunity to examine that and see where Congress and the bureaucrats have gone wrong.
Perfect segue. Okay, can you explain? Okay, so I'll give a little bit of background for people. The U.S. Food and Drug Administration got the authority to regulate tobacco products in 2009 with the Family Smoking Tobacco Control Act. I probably messed all of that up. With that, that came after e-cigarettes were introduced to the market, and then they issued the deeming regulations in 2016. And then what we had is all these people who were making e-cigarettes had to go apply for FDA authorization. The FDA does not approve tobacco products. And so with that, those were all due in 2020. And since then, the FDA has only approved 34 applications out of hundreds of millions. And what we're seeing is the e-liquid manufacturers who initially applied for authorization and then got denied, they went and sued the FDA, and now it's in front of the Supreme Court. So kind of trying to do it from a very small, we can go way into the details on that. Can you kind of explain why we submitted the brief and some of the points that we did? And I know that we're on the side of the respondents for people who want to, or who are looking at these briefs. We are on the side of the e-liquid manufacturers, and against the FDA, we're yelling at them that, that it was arbitrary and capricious.
Sure, no, that was an excellent recap, and it's very easy to get lost in the legal mumbo jumbo. But basically what the Supreme Court is looking at is whether the Food and Drug Administration acted what's called arbitrarily and capriciously in denying certain products. And the products that we're looking at and that are under examination by SCOTUS are liquid products that are manufactured by Triton. And basically what this case is all about is looking at the Food and Drug Administration's approval process for these products. And all of these products, by the way, whether it be vape pens or whether it be open system vapes or whether it be liquid products that you're using to fill open system products, is the FDA acting according to law, according to the letter of the law, and impartially evaluating these products to approve or deny? And we're making the case that there is a lot of lawless activity going on. And essentially the FDA's decision to deny some of these products is just not within the realm of the law. Well, first of all, the law is very, very difficult to make sense of, as we will discuss a little bit later on. It's written in a very vague way, very, very difficult to make sense of. And two regulators reading this law can come to two very, very different conclusions about how to apply it. But there are some clear parts of the law, and even on these regulatory clear points, the FDA is absolutely misapplying the legal analysis that it is supposed to apply. So we're arguing both of those points in tandem and coming to the conclusion that this FDA decision not to approve these products that right now this decision is under evaluation by SCOTUS, that decision cannot withstand legal scrutiny.
Yeah, I think you're talking about the vagueness. You're talking probably about the APPH, the appropriate for the protection of public health, which is very vague, and that's one of the things that the FDA has been looking at when they're authorizing these products or not, is whether they're appropriate for the protection of public health, and the way that they're applying it makes no sense, especially when you're looking at in 2023, the FDA authorized the sale of 663 combustible cigarette products and 0 e-cigarette products, and we do have the science that proves that e-cigarettes are substantially less harmful.
Yeah, and the FDA has purview to approve or deny a lot of different products. And we're not just talking about vaping products or tobacco products. We're talking about drugs, and we're talking about medical devices as well. Now, usually when Congress gives the FDA the authority to approve or deny these products, they give, I would say, relatively clear direction. So for example, if you are a drug manufacturer and you want to bring a new drug to market, first, the burden or onus is on you, the drug manufacturer, to make a claim about what is your product supposed to do. So for example, if I'm bringing a statin to market, I will make a claim that it lowers the amount of cholesterol in the blood. And then once you make that claim as a drug manufacturer, it's up to the FDA to look and see if there are well-controlled investigations, basically state-of-the-art statistical investigations to support what the drug manufacturer is saying. Now, in that direction from Congress, there's a little bit of ambiguity. So what does well-controlled mean? I mean, reasonable people could disagree with that. But basically, the drug manufacturer is doing most of the work in honing the analysis. And at least the FDA can say, okay, what is the cause and effect here? And the cause and effect are already defined. The relationship between taking this drug in a certain quantity and the outcome of lowering the amount of cholesterol in the blood. So that's a relatively narrow analysis that Congress assigns to the FDA during the drug approval process. Not perfect by any stretch of the imagination, trust me. The TPA has talked for years about how this is way too strict, and Congress can absolutely rewrite this law to make for a more flexible regulatory process. But for all of its faults, at least relatively well-defined guardrails in this analysis. But this tobacco product determination that you were just talking about, this APPH standard, well, okay, so backtrack all the way back to 2009, President Obama signs into law something called the Tobacco Control Act. And what is the mandate here? Well, the FDA is tasked with approving or denying a product based on whether that approval would be appropriate for the protection of the public health. A lot of those in there. And what does this, it's so much broader than any other approval process that Congress assigns to the FDA. What does that mean? Public health can mean a million different things. It's not only the relationship between, let's say, cigarettes or vapes and lung cancer, which maybe is what comes to mind immediately. It's things like obesity. It's things like various vitamin deficiencies, but it's also, if you don't approve this product, what's going to happen? Black market activity is going to proliferate, and that has all sorts of negative effects on public health too. There are a million different public health variables, and public health is a ridiculously broad term. And the point that we're making is basically Congress is writing a letter to the FDA through this legislation saying, do our jobs for us, because it's just not narrowed down. And that's not okay from a constitutional perspective. I mean, if a law is sufficiently vague, or I would call it irreducibly vague, and you can't make any sense of it, and it's basically just Congress is saying the FDA do our homework for us, then that can't stand.
I'm glad you mentioned that about the definition of APPH, because I think most people would say this fairly simple. You know, you have vaping products which are orders of magnitude less harmful than combustible tobacco. So surely their being authorized would be appropriate for protection of public health if people switch to them. But you're saying it's more complicated than that.
Sure. And what you're describing is a necessary part of that analysis. And one thing that Congress elaborates on is you need to assess things like the switching likelihood away from conventional tobacco products to vapes. So that is definitely one part of the analysis. And something that we'll get to in a bit is the FDA flunks even that little necessary part of the analysis. But it is clear in the legislation that's not a sufficient part of the analysis. And even besides all of that, you need to weigh that against all sorts of public health variables ranging from obesity to Parkinson's disease, and then you need to let in that illicit analysis. Now, if Congress said to the FDA, I want you to weigh the switching likelihood and the lung cancer effects of switching from cigarettes to e-cigarettes more highly, put it on a pedestal above things like Parkinson's disease and obesity and the analysis of disapprovals and illicit uptake, that could be legally permissible, but there's no ordering scheme whatsoever. It's a free-for-all. And Congress is saying to the FDA, do your homework for us.
So which parts of the case are arbitrary and capricious is the words you use? Which parts are you focusing on in this brief that you think that the FDA has applied wrongly?
Sure. Well, that goes to the switching likelihood. So one relatively, we could call it, I don't even know if this is a word, unvague. We could just say less vague part of the analysis is for the FDA to assess the switching likelihood away from tobacco products. So what that reads to me, at least, is do the analysis that we've all been doing in this harm reduction field for years and say, well, does vaping encourage cigarette smokers to kick their deadly habit, right? Take up vapes, and might there be some obvious public health benefits that way? But I'm arguing that, okay, so this is a relatively less vague part of the analysis, but even this relatively clear direction from Congress is not being heeded by the FDA. So the FDA, in its denial of Triton's products, could have said, okay, we're doing this analysis, but after doing this analysis, we found that, I don't know, for example, there is no switching or there is no aggregate benefit even after doing that switching analysis. But the FDA doesn't even do that. And they justify taking the shortcut away from conducting that analysis by saying, well, we already have some approved products on the market, so they could carry all the public health weight of switching. So what's another product on the market? Why, it's all a downside and no upside. So the FDA takes that shortcut, but we argue they can't take that shortcut. I mean, it's in the clear letter of the law, number one. But also, if you look at the market dynamics, the FDA has allowed so few reduced risk products on the market that allowing another product on, I mean, that ensures far more availability of these harm reduction products on the market. Now, if you have 1 million products on the market, maybe I could understand that point that the FDA is making a little bit more. I could understand that shortcut. But if you have a situation where 99.9% of products are being denied and you have I think you only have 8 product families on the market, then if there's any sort of disruption whatsoever to manufacturing, for example, a hurricane, I don't know where I got that example from. But if there's even a little bit of a disruption, then all of a sudden you have, flavor or no flavor, closed system or open system, people who are trying to kick the habit of smoking cigarettes, they're just going to have no options to turn to because in aggregate, there are so few products on the market. So the FDA still needs to take this switching analysis into account.
Yeah, and one of the things I kind of want to emphasize for our viewers who might not be aware too, the most troubling thing with the whole Tobacco Control Act is the predicate date on that if what's considered a new tobacco product is that if it's been introduced to the market after February something of 2007, so that applies to pretty much every e-cigarette product are these reduced nicotine products, which is again kind of ignores the science on it and when you're looking at bringing a product to market. But I don't like the FDA at all. I'm just still kind of amazed when you look at since 2000 and they started pretty much issuing authorization orders since 2012 and 2000 since then they've issued 16,000 orders for combustible smokeless products. They've only issued 56 orders using the pre-market tobacco application process, which is that new process that you have to do to if you came in after 2007. So moving into that, I guess looking at the Supreme Court case, I know that I was talking to another lawyer who we've had on the show, Greg Troutman, who's been instrumental on with one of the firms working on that case. Do you think that they will address the predicate date?
Honestly, there is so much that they need to address. And these opinions, they tend to be pretty long. It's hard to say exactly whether they'll address that date. I think that the thing that they're the most likely to address is actually the point brought up by Troutman and others in their briefs, which is the arbitrary and capricious analysis, but applied to another issue that they identify and that the Fifth Circuit has raised. And this analysis has to do with the FDA at first saying in their guidance to industry, you don't really need to focus on statistical analysis of any kind on for example, the likelihood of switching and the average benefit of switching. Instead, we just want to be convinced by you, industry, that kids are not going to have access to your product. So show me a plan that you have in the books to make sure that kids do not have access. So a bunch of manufacturers said, okay, we could give you all sorts of plans to make sure that this is the case and kids will not get access. And then the FDA does a 180 and releases guidance after a bunch of PMTAs are submitted. And they say, no, we're just kidding. You actually do need to conduct robust statistical analysis. So I think the court is probably more likely than anything else to focus on that question, because if a regulatory agency says one thing, like this is what you need to do, and then there's a lot of reliance on that guidance or that rule, and then there's a switcheroo, as the Fifth Circuit calls it, and there's something completely different, then that goes also to the heart of the arbitrary and capricious standard. Now, in terms of the strategy of these briefs, it's usually advantageous for all of the parties writing in, let's say on behalf of the respondent, to all have different arguments. We don't want to reinvent the wheel too much, but we want to have substantively different arguments for the Supreme Court to evaluate. Otherwise, you're going to have justices and their clerks reading the same argument over and over and over again. So I wanted to make sure that I took this arbitrary and capricious question, which is what SCOTUS is looking into, and I used it. I basically used it in a different, in a subtly but significantly different way than what Troutman would focus on. But I think that Troutman and others' analyses are probably closer to what the Fifth Circuit looked at in the beginning. So I think that's probably what SCOTUS is going to focus on, more than really any specific dates or really anything else. I think the heart of this analysis is going to be the arbitrary and capricious analysis.
Yeah, I noticed that I think there's eight in total. Is it 8 amicus briefs in total from big tobacco company and from independent business, and one from 13 members of Congress and the American Center for Law and Justice. So are they all making different points? Are they all or are they all much of a muchness, do you think?
It's probably a little bit of both. I think that it's hard for, let's say, if you have even 5 different amicus briefs and a narrow question being posed by SCOTUS to all have completely different arguments and completely different claims. But I saw, for example, that one brief really just focused on the data about the benefits of e-cigarettes relative to cigarettes. So it's basically reference material for justices and clerks going through this data. And, these guys at the Supreme Court, I mean, they focus on so many different issues. It is amazing the breadth of issues that they focus on. So they're probably looking at this issue and they're like, oh, what is the deal with vaping and cigarettes and the intersection thereof? So it's very important to have those sort of briefs that serve almost purely as reference materials. And then there's probably going to be some overlap, basically with briefs saying, yeah, the Fifth Circuit is absolutely right, and here's why we think so. And those sorts of analyses will be very similar. We wanted to do something a little bit different, but we didn't want to reinvent the wheel. So I feel like we're maybe a little bit in between. But to answer your question, it's hard to completely avoid overlap, but you try to do it as much as possible.
And does the fact that there are 8 of these and they're all in support of Triton, does that weigh on the SCOTUS's mind when it's making a judgment, thinking, well, there's 8 groups who are sufficiently animated about this to take time to submit these briefs?
I was doing the counting for petitioner and for the respondent, and I was thinking, oh yeah, like what is SCOTUS going to think about the relative numbers? I think it has more to do with the arguments though, because you can imagine a situation, I'm sure this has happened before, where you have 50 amicus briefs and they're all making the exact same point, and Gorsuch is like scratching his head like, why do I need all this duplication? I'm busy enough already. Stop bothering me. Leave me alone. So I think the value added of each additional brief is what matters, even though it is fun to count them and say like, oh, how many does each side have?
Yeah, that was what I was really surprised that you didn't see a lot of the people who were in favor of the FDA. I mean, we had our usual suspects: Campaign for Tobacco-Free Kids, Bloomberg groups, couple members, 16 members of Congress, including, Dick Durbin and Raja Krishnamurthy, who they've been wasting a lot of taxpayers' money going after e-cigarettes in Congress. Will this have any impact on any of the other centers at the FDA?
Oh, that's a good question. I mean, if SCOTUS sends a signal to the FDA saying this is not the Wild West, you need to hew closely to the rule of law, then I think it might. I think that, for example, drug approval and medical device approval, the regulators might more closely pay attention to the letter of the law and make sure they're staying within what court precedent calls the zone of reasonableness. And they might realize that the tax on having kind of like a novel legal interpretation that falls outside the bounds of the law may just not be worth it. So one example of that from, I think it was probably about 25 or 30 years ago, there was a relatively activist head of the FDA, and I'm pretty sure that he proposed regulating cigarettes as a drug, which would really be reinventing the wheel. And Congress, the court said, no, this is not a permissible interpretation. But it wasn't for lack of trying on the FDA's part. So I think the FDA, at least occasionally, will try to make a determination just to kind of like test the waters and say, well, it's a little bit of a stretch from the congressional language. Let's see what the courts have to say. But the courts can shape agency attempts to do so in the first place by saying, nope, here are the guardrails. You need to really make sure that you're paying close attention to the letter of the law.
And if it maybe not so, how much will Reagan Udell Foundation's criticism of the CTP play into this debate? Will that be taken into account? Has that been mentioned by any of the respondents?
That's a good question. I'm not sure. Do you have more context based on what you've read about that, or?
Well, Reagan Udell was quite critical of how the Centre for Tobacco Products was operating. Released a report, I think it was last year, and there was some, fairly robust criticisms that they laid, and I think the CTP had to go away and the FDA had to look at restructuring or speeding up their actions. So they have had criticism before, and I just wondered if that would sort of emerge somewhere in the debate.
Oh, it's certainly possible. I think that the FDA is trying to restructure anyway, regardless of what the court says. There's been a lot of outrage, particularly over their handling of the infant formula issue. And that outrage, I mean, first of all, it's definitely come from the public. And there's been a lot of, how could we be in a country where there's not even widespread availability of infant formula, which it's definitely not a mystery about how to make this product and scale it up. So what's with these supply side vulnerabilities and regulatory barriers to entry? So there's definitely sort of like public swell pressure on the FDA to reorganize based on that. And that trickles up to Congress, and Congress says, FDA, what are you doing? Why is this so bureaucratized? Are we going to reorganize? I think those are the main determinants for pressure for the FDA to reorganize, but we will see. Foundations are very instrumental for talking to Congress and saying, these are the issues. This is why you're seeing such substandard results in, for example, food and drug inspection.
Funny enough, it was the infant formula that was going through my head when you were talking about the hurricane knocking out production, because I was thinking, I remember the headlines, even in the UK, you could read the headlines about how Americans couldn't get hold of this product. And exactly as you said, it seemed bizarre, the United States of America, and you can't get this product anywhere.
Yeah, we've been making this product for a very long time. It's not rocket science to make this. I mean, look, I personally couldn't make this product, but a bunch of smart people can make this product, right? With sufficient resources and know-how. So it was a mystery. And what we see, I think, is a very familiar pattern, and that you have regulatory barriers to industry that spur consolidation. Now, consolidation, concentration is not a bad thing at all necessarily, but what happens is if it happens as a result of too much regulation, then you'll see a lot of artificial consolidation, and it creates a lot of choke points in the supply chain. And then if, God forbid, you have one facility that gets wiped out, then you have a huge disruption of supply. And then there's a lot of pressure on the FDA saying, how come there are so many choke points, and how come the barriers to entry are so high to begin with?
Mm-hmm.
Perfect conversation. It went by so quickly. We're kind of getting towards the last 5 minutes of this. I always kind of like to end with a positive note on these podcasts, because we're usually complaining about everything. So I guess, Ross, do you have any, advice to our viewers who are following this? Friendly reminder to our viewers that Supreme Court will be hearing oral arguments for the case that we're talking about on December 2nd. So it's going to be interesting to see what happens with the election and how much that may or may not, impact whatever they come up with. You got any final thoughts, Ross?
Sure. Well, definitely stay tuned. This is not the last that we've heard of this issue. This will certainly come up again as these arguments develop. And one sort of piece of advice or broader takeaway that we can sort of glean from this issue is, when we're looking at this arbitrary and capricious analysis, this just does not just apply to the FDA. This applies to any federal and state agency, for that matter, under the sun. And we need to pay close attention to sort of takeaway examples. And if someone is working, for example, in another industry where it seems like the government has run amok and is not operating, again, within this zone of reasonableness, let's see how we can apply that to other areas of the law and make sure that agencies are doing their job, and that they are respecting rights, and they are paying attention to the letter of the law. I mean, it is super important.
Can I ask you one last, it might be a silly question. Now you made this submission on behalf of the TPA, is that it, or do you get to go and address Supreme Court?
No, I don't get to. That would be really cool and really intimidating, but no, I don't. No, maybe someday though.
Yeah, okay, yeah.
That would be cool. And very scary.
Something tells me the Supreme Court might be a little bit easier than Congress, right? You know what I mean? That's all right.
Listening to some of these oral arguments, these justices, oh my God, they're all so smart. And you're already sweating because you're in front of the Supreme Court and you're answering all these questions. And then you'll have a justice that'll pose this really on point hypothetical. And then in your brain, you're like, oh, I never thought of that. That's really, I had no idea how to answer that. You could just say, I don't know that. I mean, that's probably, we need more of that, right? We need more,
Honestly,
in this day and age, we need people to say, like, I don't know.
That's a great question. I can get back to you. Let me go do some
right,
research.
I'll get back
yeah. Well, thank you for coming on, Ross. Martin, do you want to close it out, or do you want me to close it out?
I can close it out if you like. Yeah, thanks very much. It was fantastic hearing all about it, and it was a fantastic brief reading it. It's a work of art, and I was proud to be part of the TPA with you sending that in. So thanks very much. Yeah, thanks for everyone if you're watching and we'll hope to see you again next time with another guest on Across the Pond with me, Martin Cullip, International Fellow, and Lindsey Stroud, Consumer of the Consumer Centre, the Director of the Consumer Centre, and of course Ross, who is a Senior Fellow at TPA too. So thanks for watching and see you next time. Bye.